Welcome to this talk in the context of Blutopia-Forum Mediterraneo. Today we will discuss about a very important topic, which is the seafarers' protection in the context of the Russian Ukrainian conflict from IHL point of view, so perspective. We will do that thanks to the presence of Alba Grembi, to whom I give my warm welcome. So thank you for your presence, Alba, and thank you for the time you will dedicate to us and for the sharing of your knowledge on this topic. You are a doctoral candidate at the Faculty of Law, Chair of Public Law of the European University Viandrina in Frankfurt, in Germany. Supervised by the naval war expert Professor Wolf Einchel von Heinegg. And you have been a former guest researcher even at the University of Geneva, supervised by Professor Marco Sassoli. You have been, among others, producing various articles on international humanitarian and human rights, criminal and economics law. I will not go on because otherwise we will we will not have enough time to listen to you. And but if you allow me, I would just give a bit of context before asking you some questions. We will, as anticipated, the topic of today concerns the seafarers' conditions, and just as a not a coincidence, but just to remember that 5 days ago it was the Seafarers Worldwide Day, and so this topic falls precisely, this discussion, this talk falls precisely in a week dedicated to seafarers. And in particular, we will focus on our talk. We'll focus on seafarers of enemy and the neutral merchant ships. But as I was saying, just to give a bit of context, we all know that shipping, as many other industries, has been and still is impacted by geopolitical events, and so namely in this case the Ukrainian-Russian war. And of course the impact is multifaceted, as you can imagine, because the impact of war on shipping regards safety, security, commercial, insurance, environmental, and also humanitarian, and which is really our lens to discuss this topic today. And we can start giving some figures. I mean, at the beginning of the war, in the very first period, as of the outbreak of the war, more or less 2,000 seafarers have been, were stranded aboard more or less 100 ships, which were stuck in the Ukrainian ports. And then, although this number has been reducing throughout the time, also thanks to the agreement, so-called Black Sea Grain Initiative, which has created a safe humanitarian corridor from some Ukrainian ports to the Mediterranean through the Bosphorus Strait and the Marmara Sea, of course. Still, there are, seems at today's date, a few hundreds mariners which are there without way or without many difficulties to leave, basically, the ships. And not to forget that many ships have been damaged. Some ships have been sunk to avoid the passage and the transit in some areas. Some ships have been seized. So all this to say that seafarers have been and still are definitely some of the collateral victims of this war, which is far from ending, and that's why this topic, we both believe, we've been discussing this, is still a hot topic. So I do not want to steal too much time, but I thought it was important to give some context. And so my first question to you is really, let's start understanding what's the status stranded mariners or on merchant ships, and also to understand if there is any difference between enemy and the neutral merchant ships, and if there are any obligations from the belligerent parties depending on the enemy or neutral status of mariners' vessels. So I know this set of 3 questions is not easy to answer in a few minutes, but it was just to give a sense of the theme and the focus we wanted to concentrate on.
First of all, thank you very much, Andrea, for inviting me to have this conversation and for allowing foremost the problem of stranded seafarers a chance to have some much needed light shed on it. To answer your question, provided that they refrain from acts of hostility, these mariners qualify as shipwrecked persons under international humanitarian law. Reading the Second Geneva Convention of 1949 and the first additional protocol to the Geneva Conventions of 1977 in detail, and following the interpretation provided by the International Review Committee of the Red Cross in its commentaries to their relevant articles, one understands that persons finding themselves in peril or at sea or other waters because of misfortune having affected them or having rendered their vessel disabled qualify as shipwrecked. And therefore, I'm being very descriptive here, but stranded seafarers who are in peril, in need of rescue and in peril, may enjoy the protection granted to the wounded, sick, and shipwrecked members of the armed forces at sea by international humanitarian law. And there is a difference between, of course, enemy and neutral merchant ships at sea. The conditions for capturing or targeting neutral merchant vessels are stricter than those concerning enemy merchant vessels. The former may be captured and attacked after having been provided with due warning, or destroyed only exceptionally if it is verified that they are carrying contraband or they have have violated the conditions of their neutrality. On the other hand, enemy vessels may be captured as prize and destroyed, but only if the ship's passengers, crew, and documents are first transferred to a place of safety. Those that fail to obey orders to stop and resist visit, search, and capture qualify as military targets. Concerning the belligerent obligations, these change according to the enemy and neutral status of the vessels, as you may as well have comprehended, as all mariners share the rights and obligations that come with their vessel status. So the difference between neutral and enemy merchant vessels is very significant for their humanitarian protection, as the Second Geneva Convention only refers to crews of the merchant marine and the civil aircraft of the parties to the conflict. This means that members of the crews of neutral merchant vessels that have not, and the civil aircraft that have not directly participated in the hostilities are excluded from this scope. And
so I will say thank you for all this overview. Although in a very few minutes, it's not easy to reply to these answers. I will come back to a factual background. I mean, as a matter of fact, seafarers on board ship vessels have been deprived of the fundamental services and needs. so that even the IMO since the beginning has deplored the attacks, of course, at commercial vessels, and has highlighted that seafarers should not be again collateral victims in this political military crisis, and so proposed to open corridors, of course, that any harassment of seafarers due to their nationality should be condemned. Seafarers highlighted that seafarers should have access to communications, of course, to their wages, and so on. So the second and last set of questions for you is to try to understand a bit more into detail what's the protection granted to mariners under IHL, and if the described, I mean, the just mentioned conditions of seafarers represent a violation under an IHL point of view.
Concerning our first question, this again depends on the neutral and enemy status of their vessels. So under the Second Geneva Convention, the shipwrecked, wounded and sick members of the armed forces on board, and of course these mariners that are included under the scope of the Second Geneva Convention, these who are on board enemy vessels may be respected and protected and cared for and provided with humane treatment without any adverse distinction. It is important here to note that the concept of care does not only include medical care, but also sufficient food, health and hygiene standards, clothing appropriate to the environments, and various other elements that, in my opinion, continue to develop with the development of international law in general and possibly the medical science. If not able to fulfill these obligations near the place of their collection, belligerents must transport them as rapidly as possible to a place where they can do so without under better and more secure conditions, so without any peril around them. They must also take all possible measures to search for and collect them after each engagement, without delay and without any discrimination as regards their belligerent affiliation. If not able to do this as well, they can resolve to appealing or allowing the civilian population or aid societies to assume this role, without threatening harm, prosecution, conviction, or punishment for their humanitarian acts. On the other hand, mariner crews of neutral merchant vessels can be classified in two categories. First, there are those whose state of nationality lacks diplomatic relations with the state, the belligerent party in the hands of which they are, and these persons may be protected under the Fourth Geneva Convention. In my opinion, they are protected. Under which this convention, parties have various obligations, such as endeavoring to conclude local agreements for their removal from besieged or encircled areas. And second, there are persons whose state of nationality maintains normal diplomatic relations with the state in the hands of which they are, and these are not covered by the Fourth Geneva Convention, as their diplomatic representatives may take active steps to protect them. In any case, since their condition is related to the armed conflict, they enjoy as a minimum the fundamental guarantees of IHL. As the committee has commented, the ICRC, all wounded, sick or shipwrecked persons, even those that are excluded from the category specified in the Second Geneva Convention, are entitled to respect, humane treatment, and the care which their condition requires. This, in my opinion, again, includes the obligation to take all possible measures to collect them without delay, as this is a fundamental duty, a part of customary law that enables belligerents to fulfill their other duties. And we should also mention very quickly the case of mariners who have personally participated in the hostilities or have served as naval or military auxiliary for the enemy. Under conventional and customary law, they enjoy the prisoner of war status, and this is very characteristic for the naval warfare. And they may be interned on board a warship or a captured ship, but only temporarily. Well, in this case, they will be subject to the laws binding the navy of the ship that has captured them, including, not according to me this time, but to the naval expert Heinz von Heining, human rights law. However, on the other hand, neutral mariners who are on board captured vessels and have not committed acts of hostility may not be made prisoners of war and must be repatriated without undue delay. Concerning your, yes.
Please go on. No, that's absolutely interesting, but please go on.
Concerning your question on the violations, before answering this question, it is important to stress that our ability to know what is happening in the area is considerably limited by a chronic condition that we have, which you may as well be familiar with, that is called the sea blindness. Thus, I have to say that it is still quite soon to determine violations with certainty, as we must also consider circumstances which govern each situation, and this would need more information provided by the belligerents and maybe from third parties, which we don't have.
Definitely, access to information in our context, I mean, it's a particularly hard issue.
Yes, it's very
however,
hard.
you were saying, please?
Yes, in my opinion, the mere fact that the process of removing these mariners from the area has been so slow is contrary to the belligerent obligation to collect them without delay and transport them as rapidly as possible to a place where they can be securely cared for. Information published by the IMO, which you mentioned, suggests that ships lack food, fuel, water, and other vital supplies that point to a violation of the duty to care under the Second Geneva Convention. Also, there is an indication that other obligations have been violated, such as the prohibition to use naval mines that fail to neutralize 1 hour after control over them has been lost, and maybe to use neutral vessels as shields and attack them. All these facts also point to a humanitarian crisis that states have not been so urged to solve in due time. And this fact is not at all encouraging, as it represents an indicating factor of the general intentions of the parties in this naval warfare. Of course, and hopefully, further information may end up disproving most of my current views, and this would be actually a very positive development.
Thank you. I believe we have an issue with your camera since 1 minute, but I mean, the audio was perfect. So thank you for for sharing your knowledge on this. And now seems that the issue is fixed with the camera. Thanks for sharing your knowledge and helping all of us to see one of the impacts of the war on shipping through the lens of humanitarian law. You will be always welcome should you wish to participate again in one of the next talks, giving your expertise and from your point of view. So, I mean, I wish you all the best for your researches and then your and your work. I know that you are very busy. So I will not keep you more than this today. But I sincerely wanted to thank you again because it was really interesting and absolutely clear to
Thank
me,
you.
and I hope to everyone who is going to watch the video. Thanks again.
Thank you for inviting me, Andrea.